This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Page 91, Chapter 12, Company Law Meetings and Resolutions. I love this topic. I don't know why, but students hate it. The general perception, over many years, the general perception is that students detest the topic of meetings and resolutions, and yet it's all very clear. There's lots of percentages and periods of time involved in it. Is it this? Is it that? Must it be? What are the exceptions? It's a fascinating mini topic within the overall fascinating topic of law, but students hate it. So be prepared at our next mini break to be talking amongst yourselves saying, my God, that was awful. Public companies must have an AGM. Private companies don't need to. Private companies do no longer need to have an annual general meeting. It only changed in 2006, but a private company can do without the requirement of an annual general meeting. It shall have, a private company shall have an annual general meeting if any member, I think holding more than 5%, if any member asks for one. You're not likely to. They're expensive. They're a waste of time for a private company. It's a waste of time. Imagine, I'm just going to marry you for a moment, Christine. You won't know a thing about it. Imagine a husband and wife company, a private company. What's the point of us having an annual general meeting? What is the point? We have one every morning over the cornflakes. Let's have an annual general meeting, shall we? It just is ridiculous. But there are some big private companies. There are some enormous, I keep saying it, some enormous private companies, and they probably will be expected, or voluntarily, they will say, we're going to have an annual general meeting. But otherwise, no, I'm divorcing you. We're finished. It didn't take 7 years. But so public companies must hold an AGM, and they must hold it out every calendar year. I don't know whether that is so obvious, it doesn't need stating, but it actually did go to court that a company must have an annual general meeting in every calendar year. The first one shall take place, it says here, no more than 18 months after incorporation. Technically, it should say no later than 6 months after the year end. That's not more than 18 months after incorporation, is it? No more than 18 months after incorporation. Subsequent meetings shall be held within 15 months of the previous annual general meeting. Private company members can request an AGM. The AGM itself shall have 21 days' notice. No matter what type of resolution is to be proposed and discussed, an AGM gets 21 days' notice. And the prime purpose, or the prime purposes of an annual general meeting are to discuss the ordinary business of the company. The ordinary business is a technical expression. It's defined, and there are 4 elements. The first of these is to have and accept the formal presentation. Now, I hesitate to use the word approve. In fact, it's not the general meeting that approves the financial statements. That approval is done by the directors. It's their job to approve the financial statements. But having approved them, and the auditors then having signed their audit opinion, these financial statements then go for printing, then they come back, then they get circulated and sent out, maybe emailed to the shareholders, the members of the company, together with the notice of the meeting. And the notice of the meeting will have an agenda. And the agenda says the purpose of the meeting is to discuss, and if thought fit, to approve, to agree the formal presentation of the financial statements, the appointment of directors who are retiring by rotation on this 1/3 rotation procedure, to reappoint the auditors for another year, I've got to be very careful there. That's precise wording. To reappoint them for another full year. And finally, to confirm the dividend which has been proposed by the directors. The directors will propose a dividend, maybe before the year end, in which case it will be reflected within the figures, maybe after the year end, in which case it will not be reflected in the figures, but it will be disclosed as a disclosure note. But that's the ordinary business. The formal presentation, all of you had a copy of the financial statements. Is there any questions with reference to the financial statements? Does anyone have any comment about the financial statements? Any questions at all from the floor? So can we approve then the formal presentation of the financial statements? Okay, the next item, ladies and gentlemen. Next item on the agenda is the discussion and, if thought fit, the reappointment of Benita, retiring by rotation as a director. All those in favour? Against? Benita's appointed. We appointed Madra partway through the year as a director. Madra is retiring not by rotation. She's retiring because she has to, because she was appointed by the other directors during the year. So this is not ordinary business. The appointment of Madra as a confirmed new director is not ordinary business. It's only the reappointment of directors retiring by rotation that is ordinary business. The confirmation of a new director, or the reappointment of a director over the age of 70 for a public company, these are not ordinary business. If they're not ordinary business, what are they? If it's not ordinary business, what sort is it? What did you say, Sandra? Did you? Yes. Yeah. If it's not ordinary business, by default, it must be special business. And therein, I think, is the basis of the confusion. Because we've got special resolutions, 75% changing name, changing constitution, 14 days notice. We've got special notice, which only ever applies to an ordinary resolution. And there are only 6 ordinary resolutions that need special notice. He's not likely to ask you and say, what are the 6 ordinary resolutions? He's not going to ask that, but he may ask you what you understand by the expression special notice, and give 2 examples when special notice is needed. And I have given you 3 so far. I've given you 3 circumstances where special notice is required. No, that's a special resolution changing the name. Reappoint an overage director to a public company. A director over the age of 70 is reappointed by an ordinary resolution, but the notice period is special. No. Oh, well, yes, all right. If an auditor dies, we'll have to fill that position fill that casual vacancy. Yes, okay, that's an ordinary resolution. I hadn't given you that one previously. That's an ordinary resolution with special notice. What do you do with a director that you don't want to continue acting? You remove him. Remove a director before this term of office expires. And if you need an ordinary resolution to remove a director, what sort of resolution do you need to remove an auditor? An ordinary resolution with special notice. I don't know why students don't like this. One more time. Special resolution. Give me 2 examples. Changing name and changing constitution. Change the name, change the constitution. Special resolution, 75%. 14 days notice. Copy to the registrar. That's a special resolution. Come down from this 75% majority down to a simple majority. This is an ordinary resolution. Some ordinary resolutions require a special notice period. 3 of these Let me give you the days. Special notice is 28 days notice to the company, and the company then gives 21 days notice to the members. 3 examples. You can remember 2 because they're virtually identical. You can remember the third just by thinking about John. You can remember these things. Remove an auditor before the end of his year of office. Remove a director before the end of his year of office. And the other one is to appoint an overage, a 70-year-old director to a public company. You're not going to have to remember all 6, but there are only 6, and they're in your notes. They are here. That's special resolution and special notice. What's special business? Well, I've not told you the definition of special business. Yeah, special business is any business which isn't ordinary. And I have told you what's ordinary. Ordinary is the formal presentation, the reappointment of directors by rotation, the reappointment of the auditors for another full year, and the approval of the dividend, the approval or the reduction of the dividend proposed by the directors. Anything else is special. Anything else is special business. So by definition, a special resolution is special business. By definition, an ordinary resolution requiring special notice is special business, because it's not ordinary business. Again, a special resolution, by definition, is special business. An ordinary resolution requiring special notice is special business. It's not ordinary business, because ordinary business is just these 4. The formal presentation, the reappointment of directors retiring by rotation, the reappointment of the auditors for another full year, and the approval of the dividend proposed by the directors. Ernst Young have decided not to stand for re-election after the end of this annual general meeting, this one coming up next week. Ernst Young have decided that they've been auditors now for 7 years, and they think that's enough, that maybe their independence they feel is being jeopardized, being threatened, because they're getting too familiar with the client. So they've indicated to the client that they do not want to hold office as auditor from the end of this general meeting into the future. We'll change our mind in 3 or 4 years' time. We're back available again. But next year, they do not want to be our auditors. We're not in any fight. We've not had any argument with them. And we're very sorry to see them go, because we've built up this wonderful working relationship with them. But they feel they should leave. Okay, we'll go around. We'll phone up Pricewaterhouse. We'll phone up KPMG and Deloitte. And maybe others. Maybe the ones not in the Big Four. And get them to tender and submit their applications as to whether they want to be our auditors. Next year we're going to appoint Grant Thornton, which is a sort of number 5, although they claim they're number 4 now. We're going to invite Grant Thornton to be appointed to the position of auditor, because Ernst Young don't want to do it. What sort of resolution is needed to appoint Grant Thornton? Yeah, it's an ordinary resolution. But because Grant Thornton are being appointed, not reappointed for another full year, because all we're doing is appointing them, that needs special notice. To change your auditors needs special notice.